Okay, everyone, day 9 of the Assange hearing. Are you ready for the meltdown? Are you ready for the pretty much complete breakdown of the prosecutor? Oh my God. Craig Murray refers to it as spiteful and nasty. But oh my God, you're just going to have to hear it to believe it. So he says, on the evidence, there were stark details of the dreadful regime Assange will face in the U.S. jails if extradited. On the procedure, we saw behavior from the prosecution QC that went well beyond normal cross-examination and was a real attempt to denigrate and even humiliate the witness. And that witness was Eric Lewis. He testified that no publisher had ever been successfully prosecuted for publishing national security information in the USA. And they're going back to the Obama administration's decision not to prosecute. Assange had not been prosecuted because the First Amendment was considered insuperable and because of the New York Times problem. There was no way just to prosecute Assange without prosecuting the New York Times for publishing the same material, because the New York Times had done everything that Assange had done. The New York Times had successfully pleaded the First Amendment for its publication of the Pentagon Papers, which had been upheld in a landmark Supreme Court judgment. So he's giving evidence that mirrors what we've already covered, including the change of policy in the Trump administration, where now apparently we're going after Assange where we weren't before. But Murray, summarizing Lewis, says, the prosecution of the publisher in this way was unprecedented. The facts were the same in 2018 as they had been in 2012 and 13. There was no new evidence behind the decision to prosecute. Crucially, the affidavits of U.S. Assistant Attorney Gordon Kromberg for the taking of a different decision to that of 2013. There is no explanation of why the dossier was just lying around with no action for 5 or 6 years. Eric Lewis confirmed that if Assange were convicted, he would very probably spend the rest of his life in prison. The charges had not been pleaded as one count, which it had been open to the prosecution to do. The judge would have discretion to sentence the counts either concurrently or consecutively, which means it could range from a best case of 20 years to a maximum of 175 years. And when you consider Assange's condition and the treatment he's getting, which would be as bad or not worse in the prison he'd be going to, even 20 years might be a life sentence with him. So, the history of espionage convictions in the USA had generally resulted in whole life sentences. 20 to 30 years had been lighter sentences for espionage. Kromberg had agreed that Julian Assange would be placed in the Alexandria City Jail, and there was a risk that he would be held there under special administrative measures. In fact, this was a near certainty. Special administrative measures is basically what the rest of the world calls solitary confinement, as we'll get into. So, yes, he would be subject to special administrative measures both pre- and post-conviction. He would be kept in a small cell for 22 or 23 hours a day and not allowed to meet any other prisoners. He would be allowed out once a day for brief exercise or recreation, excluded from other prisoners, but shackled. So he's in prison, he's not around anyone else, but he still has to be shackled. And keep in mind that what he did was talk to someone in a chat room and upload some stuff to a website. So, I mean, nothing violent, he didn't, go off and beat up a bunch of people or anything like that. What are they so concerned about? No, this is about psychological torture, not anything else. All right, the 2017 decision by the International Criminal Court opened an investigation into war crimes in Afghanistan in which the evidence provided by the WikiLeaks release of U.S. war logs and diplomatic cables provided essential evidence. What took them so long, I don't know, but the ICC prosecutor's U.S. visa had been canceled to hinder this investigation. An executive order had been issued imposing financial sanctions and blocking the banking access of any non-U.S. national who assisted the ICC investigation into crimes alleged against any U.S. citizen, and that would affect Julian Assange. So at this point, the half-hour guillotine imposed by Judge Bereitzer on the direct evidence came down. Fitzgerald pointed out they hadn't even reached the second superseding indictment yet, but Bereitzer said if the prosecution addressed that in cross-examination, then the defense could question it on re-examination. We've got the prosecutor then, James Lewis. James Lewis is cross-examining Eric Lewis. Yes, there are two Lewises, so I'll just say James and Eric. James is the prosecutor. Eric is the witness. So yet again, James is being really aggressive, and he also says, Murray does, that this is not a precise transcript. It would be illegal of me to publish a transcript of a public court hearing, fascinating but true. This is condensed and slightly paraphrased. I believe it's a fair and balanced representation of what happened, but not a verbatim record. And this might run into something else that I kind of hinted at that some of you might have noticed, because I said, if anyone has the record of these witness testimonies, let me know, because the written record is supposed to be available. Well, some of you might have been going, whoa, there's links in there. There were links in these previous days. Why don't you just click on those? Well, those of you who have clicked on them might have noticed you're getting a 404 error. Yeah, so all this public data in this public trial, for some reason, they don't want us to have it. What are they so afraid of? And Murray also points out that Eric Lewis was appearing by video link, and it should be borne in mind that he was doing so at 5 a.m. his time. So, after some initial questions, are you aware of the rules governing expert witnesses and stuff like that? Lewis has been doing all of this, making a big deal of the rules, because these are expert witnesses, and he wants to say that they're not. So, James says, you are also supposed to set out alternative views. Where have you set out the arguments in Mr. Kronberg's 5 affidavits? Eric, the court has Mr. Kronberg's affidavits. I address his arguments directly in my statements. Are you saying that I should have repeated his affidavits and all of the other evidence in my statements? My statements would have been thousands of pages long. And then James goes on with how he's supposed to be unbiased, but he's clearly been arguing in favor of Assange, and what do you expect? He's a witness for Assange. So he goes on to ask, have you represented anyone in Alexandria Detention Center? Eric, yes, one person, Abu Qatada. And after some initial questioning on that, James asks, Abu Qatada was held under special administrative measures. They love that, special administrative measures. Did that prevent you from spending many hours with him? Eric, no, but it made it extremely difficult. The many hours were spread out over a long period. That's why remand lasted for 3 years. James, were your meetings with him monitored? Eric, yes. Ooh, they're not supposed to do that, attorney-client privilege. James, but not by the prosecution. Doesn't matter. Eric, it was all recorded by the authorities. We were told that nothing would be passed to the prosecution, but from many other reports, I am not convinced that is true. That's why it's not supposed to be monitored at all. No attorney-client communications are supposed to be monitored to stop even the possibility of that happening. So they go on about the risk of Julian Assange subject to administrative segregation. And Eric is saying, my experience is that national security charged prisoners go straight into administrative segregation. Now, remember, they were only allowed a half hour on direct. So all of the evidence is from the statements they had submitted earlier. And so they need to be able to go back to those statements because that's exactly what James Lewis is cross-examining them on. And so they need to be able to refer back to that. So James becomes aggressive and says, what are you reading? Eric, pardon? James, you are reading something there. What is it? Eric, it is my witness statement. He holds it up. Is that not okay? James, that is all right. I thought it was something else. Well, I mean, of course he's going to be referring to his witness statement. That's what you're cross-examining him on. And it's been a while. Judge Dalek didn't allow him to get it all in the initial questioning, so he's got to make sure that it's all, fresh in his mind, and the arguments, this is crazy. So, anyway, James says, how many categories of administrative detention are there? Eric, I just went through the main ones: national security, serious charge, threat to other prisoners. James, you do not know the categories. They are, reels off a long list. Like he was giving him a pop quiz or something, instead of, asking him questions to elicit information. Which is what he's supposed to be doing. But James's tactic is to try and make these people appear not to be experts when they are. So here we get to it. Do you agree there is no solitary confinement in administrative segregation and special administrative measures? Eric, no. Lewis, Kronberg states in his affidavit that there is no solitary confinement. Eric, it is solitary confinement other than in the vernacular of the U.S. Prison Service. James: in that case, it is also not solitary confinement in the vernacular of the English High Court, which has accepted there is no solitary confinement. Eric: it is solitary confinement. When you are kept in a tiny cell for 23 hours a day and allowed no contact with the rest of the prison population, even during the 1 hour you are allowed out, that is solitary confinement. The attempt to deny it is semantic. Yeah, I mean, it's confinement and it's solitary. So, yeah, solitary confinement. Yeah. So James asks, was Abu Qatada in solitary confinement when he was permitted unlimited legal visits? Eric: they were not unlimited. In reality, there were practical and logistical obstacles. There was a single room that could be used for the entire prison population. You had to get a booking for that one room. You had to book translation services. The FBI oversaw the visits and listened in. Now, with COVID, there are no visits at all. Theoretically, visits are unlimited, but in practice, you do not get nearly as much time with your client as you need. James: but is it not true that even prisoners under special administrative measures get a break schedule? Eric: there is a break schedule, but it requires no other prisoner to be in the communal areas to have contact with the prisoner under SAM. So in practice, the 1 hour break would typically be scheduled between 3 and 4 a.m. Not many prisoners wanted to get out of bed at 3 a.m. to walk around a cold and empty communal area. So there was a break, and James was complaining to Breitzer at this point about this 4 hour limit set on his cross-examination. Now remember, the direct examination was limited to half an hour. But here James Lewis is complaining that he only got through 1.5 pages of his questions, and Eric Lewis was refusing to give yes or no answers, but instead insisted on giving lengthy explanations, which he has to do under his oath to tell the truth, the whole truth, and nothing but. James Lewis was plainly extremely needled by Eric Lewis's explanations of unlimited visiting time and no solitary confinement. He complained that Breitzer was failing to control the witness. It was plain that James Lewis's real aim was not to get more time, but to get Breitzer to curtail Eric Lewis's inconvenient answers. It is, of course, amazing that he was complaining about 4 hours when the defense had been limited to half an hour and had not even been permitted to get to the latest superseding indictment. Breitzer, to her credit, replied that it was not for her to control the witness, who must be free to give his evidence so long as it was relevant, which it was. It was a question of fairness, not of control. James Lewis was asking open or general questions. Wow, she's being less of a Dalek today. Is this a good trend? We'll have to see. James Lewis responded that the witness refused to give binary answers. Yeah, have you stopped beating your wife, yes or no? Therefore, his cross-examination must be longer than 4 hours. He became very heated and told Breitzer that never in his entire career had he been subject to a guillotine on cross-examination and that this would not happen in a real court. He very definitely said that this would not happen in a real court. Ooh, way to get the judge completely off your side there, James. And Murray says, I have, of course, been arguing all along that this is not a genuine process. I did not expect to hear that from James Lewis QC, though I think his intention was just to bully Breitzer. Breitzer only conceded very slight ground under this onslaught, saying she had never used the word guillotine, that the timings had been agreed between parties, and she expected them to stick to them. James Lewis said it was impossible in that way to adequately represent his client, the U.S. government. He said he felt stressed, which for once seemed true. He had gone purple. Breitzer said he should try his best to stick to the 4 hours. He fumed away. Now, listen to this next paragraph from Murray. It is epic. James Lewis QC's Touting for Business webpage describes him as the Rolls-Royce of advocates. I suppose that is true in the sense of being foreign-owned. Yet here he was before us, blowing a gasket, not getting anywhere, emitting fumes, and resembling a particularly unloved Trabant. Boom! Yes! TKO from Murray. Wow, perfect. I hereby award Craig Murray the entire internet for that one. Oh, nice one, Murray. Love it. Oh, I love that one. All right, back to the cross-examination. James. Gordon Kromberg states there is no solitary confinement in ADX, Colorado. Eric, again, this is semantic. There is solitary confinement. James, but there is an entitlement to participate in 3 programs a week. Eric, not in special administrative measures. So there's a bit more, nitpicky on the different measures and different paragraphs and things like that. And then he refers to a number of paragraphs in the original district court decision of Babar Ahmad. Eric asks for more time to find the document as, I only received these documents from the court this morning. So they're doing this again. They're just springing these documents on the witnesses a few hours before they have to testify. At 5 a.m. So, yeah. James, but Mr. Lewis, you have testified on oath that you had read the Babar Ahmad judgment. Eric, I have read the final judgment of the European Court of Human Rights. I had not read all the judgments from the lower courts. I received them from the court this morning. More nitpicking that SAMs don't preclude extradition, and Eric Lewis specifying the difference between a terrorism case and a national security case. Assange is a national security case, not a terrorism case, so these really aren't that relevant. But, and James keeps trying to pin down Eric to these simplistic things, and Eric keeps saying, well, each case is different. You have to look at it, each case on their own merits. And Murray writes, there now followed an episode where James Lewis QC successfully tripped up Eric Lewis by quoting a passage from an Ahmad case judgment and then confusing him as to whether it was from the final ECHR judgment, which Lewis had read, or from an earlier English court judgment or the ECHR prior judgment on admissibility, which he had not. And so after Ahmad, James Lewis goes on to say, what are the defense issues that Assange will raise that you say makes proper consultation under the SAM regime impossible? Eric, well, I don't know the precise details of what his defense will be, but James, interrupting, again, you don't interrupt a witness's answer. Well, how can you possibly know what the issues will be if you don't know the case? Eric, because I've read the indictment. The issues are very wide-ranging indeed and involve national security documents. James, but you don't know what defense at all will be put forward, so how can you opine? Eric, the charges themselves give a fair idea of what might be covered. I mean, what sort of questioning is this? This is just crazy. So anyway, they're going on about the physical and mental health of prisoners and the concern that Assange will not be getting proper care in a prison. And Lewis mentions the U.S. Bureau of Prisons states that 48% of prisoners have serious mental health problems, but only 3% receive any treatment. The provision for mental health care in jails has been cut every year for a decade. Suicides in jails are increasing by 18% a year. James, have you read the Treatment and Care of Prisoners with Mental Illness by the U.S. Department of Health? Eric, yes. James, you purport to be an expert. Without looking up what year was it published, you don't know, do you? Wow, continuing with his little game of Trivial Pursuit there. He doesn't remember the exact year it was published, so he must not be an expert. And Eric simply responds, could you be courteous? I have been courteous to you. Can you refer me to a relevant question? James Lewis is being completely outclassed here. So, just a couple of questions, attempting to attack Eric Lewis's credentials later. And then James Lewis QC smirking. How many levels of psychiatric assessment are there? What is level number 3? What are you reading? You are reading! What are you reading? What are you reading? And Murray says, yes, this is not a mistake. He did pull this stunt again. And Eric said exactly what he said before. I am looking at my own witness statement. Shows it to camera. James, you are not a genuine expert witness. You have no expertise in these matters. As you are being paid to give evidence and are not an expert, that is something the court will have to take account in deciding what weight, if any at all, to give to your evidence. Now, again, he's supposed to be asking questions. If he wants to argue that there's something about Eric's replies that calls his expertise into questions, he would make that in arguments after the fact, when he does his closing or whatever. Or he might, after the testimony, make a motion to the judge to have the witness discarded as a non-expert or something like that. You don't do that directly to the witness. I'm not a lawyer, and I know that. But he says it to Eric Lewis, so Lewis gets to respond, except he didn't because the video link broke down, rather bizarrely broadcasting a news item about Donald Trump attacking Julian Assange. It could not be restored all day, so that was the end of proceedings. This hearing has frequently been interrupted by the strange incompetence of the Ministry of Justice in establishing simple video links. And he goes on to say, James Lewis QC's conduct was very strange. It really is not normal courtroom behavior. Were there a jury, they would have completely written him off as rude and obnoxious, and even Bereitzer finally seems to have found her limit of being pushed around by the prosecution. Eric Lewis is obviously a very distinguished man and a lawyer with immense experience of the U.S. system. Trying to claim he has no expertise because he is not a psychiatrist or an academic in penology is no more than a shoddy trick performed in a manner designed to humiliate. The asking for the precise title of one particular Department of Health pamphlet or for a specific point on it, or if you remember, he was asking him for the exact year. What year was it published? You don't know, do you? As though that were a way of invalidating all that Eric Lewis knows is so transparently invalid as a test of worth that I am astonished Bereitzer let James Lewis pursue it, let alone the histrionic accusations about reading. This was really hard to sit through silently for me. Goodness knows what it was like for Julian. The mainstream media are turning a blind eye. There were 3 reporters in the press gallery, one of them an intern, and one representing the NUJ. Public access continues to be restricted, and major NGOs, including Amnesty International, PEN, and Reporters Without Borders, continue to be excluded both physically and from watching online. I mean, that's inexcusable to me. I mean, if you want to say, okay, we're limiting the number of people in the courtroom because of COVID, okay, fine. But what reasoning do you have for not letting them watch the video link? Come on, let them watch the live stream. It's not difficult. And Murray concludes, I do not in the least discount the gallant efforts of others when I explain that I feel obliged to write this up and in this detail, because otherwise the vital basic facts of the most important trial this century and how it is being conducted would pass almost completely unknown to the public. If it were a genuine process, they would want people to see it, not completely minimize attendance both physically and online. And that's also why I'm making these video versions of it. I mean, I wasn't really planning on just reading out Murray's blog word for word, and I haven't really. I've been skipping around and adding my own commentary, but I mean, this is important stuff. This is the only guy I know of who's giving us this level of detail about what's going on in the trial, and people need to know about it. And as you'll hear in day 10, the stakes get higher. The stakes get far, far higher than anyone ever said they would. People were specifically denying how high the stakes are getting. I mean, this is important, and it's just being ignored by the press. So please share this video far and wide. Hit like and subscribe to make sure you can hear the rest. Send it to everyone you can, or at least send Craig Murray's blog around. Just make sure as many people as you possibly can know about this, know what's going on, and understand the issues, because this is so important. And if you like what I'm doing, please go to donate.bogosity.tv and give anything you can. Thank you so much for listening. We'll see you for day 10. Until then, stay strong and be free.